They always want to bring in one of their big dogs last. Aha moment. So he's wrong medically. They're eyeballing it. 1% changes the label. That's pretty iffy. Science isn't supposed to be iffy. This is the killer education.
We're back for Season 3, Episode 3 of The Art of Outsmarting with Keith Mitnik. I'm Will Lewis. In our last episode, we talked about the use of education as a tool to help expose the flaw in the defense's case. Today, we're really going to narrow that topic specifically to how we can use education to expose the flaw in the defense expert's testimony, which is always one of the challenges that we as attorneys have in ultimately showing the jury the truth. And I'm excited to have this discussion with Keith today and get some of his tips on how we can go about doing that. So Keith, last episode we spoke about the use of education to expose the flaw in the defense's conclusions in reference to voir dire, in reference to opening. Now, can we talk about, and can you talk a little bit about how you bring that education tool to defense experts?
Sure. It is critical. This is one of the areas where this really pays dividends, because so much of what the experts for the defense will do is to make their conclusion not only seem right, inescapable. They really turn it into they always want to bring in one of their big dogs last, their spine doctor, their radiologist, somebody last, some biomechanical engineer, because they treat it as an aha moment. We've gone this whole case with the plaintiff's lawyer tricking you, and now we're going to bring you the absolute, undeniable truth. There is no injury, no permanent injury, no long-lasting injury, and I'm going to prove it to you scientifically, medically. That's what they're after. Education is the beginning of the end of that strategy. So let me apply it to a few things. Radiologist is a classic. Let's start with the bulging disc versus herniated disc. That's a game they play. You can kill the game with a crash course, with a little education. You teach a jury, and you do it with your expert. Now, this is on the experts, but I will do this in opening. You can get out in front of this in opening. They're going to tell you that this was a bulge, not a herniation. And then they're going to tell you, through a doctor they hired, who they hire all the time, they pay a lot of money to, they went out and picked, he testifies for the defense, says the same thing over and over and over and over for the defense. And that is, it's a bulge, and bulges don't come from trauma. Well, let's talk about that, because it's wrong, dead wrong. You're going to hear it from all the other doctors. It's wrong. By the way, sometimes you can hear it from their other expert. They'll have a spine surgeon that says, yes, it can come from trauma. It's less likely. A radiologist says it won't, or vice versa. So, but now back to educating. Let's talk about what the difference is. We have that disc. You've already educated on the disc. Now you're just picking up on it a little further. We got the disc we talked about. When someone gets older, because the weight is coming down on it, especially if you got a low back situation, the weight's coming down, and it keeps pushing down. And you got that disc in there that's like a donut or a tire. And over time, the weight of that can cause it to bulge out. That kind of bulge is called a circumferential bulge. Fancy word for all the way around. Because if the weight's coming down, it's not going to pop out at one place. That happens when there's damage to the exterior. If it's the whole thing squeezing out like this, equally, that probably is aging. But when it's more focal, it's instead of this is all fine, but it's doing this in one area, you're going to hear that can be from aging, but it absolutely can be from trauma. Why? Let's talk about it a little. Because this is what you're going to hear. Again, this is what you're going to hear. I don't see the evidence going to show. This is what you can, but I prefer. This is what you're going to hear. The difference between, and by the way, the guy they hired that's saying this will admit if it's a herniation, that can come from trauma. But he's saying it's a bulge and therefore it can't be. Aha moment. So he's wrong medically. But I want to tell you what the evidence is going to show so you can figure this out yourself. Let's talk about what the difference is between a herniation and a bulge. Forget for the moment this all the way around, circumventual, all the way around bulge. Now we're talking about all the rest of the bulges. Here's the difference between herniation and a bulge. It's just a matter of degree. It's not how far it's sticking out. It's how much of the circumference is sticking out from an around, not an out perspective. If it is sticking out less than 25%, they call it more focal. If, for example, if it was sticking out like this, here's the circle, sticking out like this, sticking out like that. That's a very narrow area. That's a herniation. If it's sticking out like this, that's going to be close. It could be either. If it's sticking out like this, it's probably a bulge. It's a matter of not how far out this way. I realize I got my finger on the backside. You can't see it. If it's sticking out like this, that's going to be a bulge. If it's sticking out like that, it could be either. It's going to be close. If it's sticking out like this, it's probably a bulge. Herniation, either or maybe, bulge. Not how far here, how far around the circle. So if it's less than 25%, this is what you're going to hear. That's defined as a herniation, of which they say can cause some trauma. If it's sticking out 25% or more, it's considered a bulge, which they say can't be, which we agree if it went all the way around. But now we're just talking about a little more, because think about this, folks. This is what you're going to hear. If it's 24%, we call it a herniation. If it's 25% of the whole 380, then it's considered a bulge. And you know how they tell? Eyeball it. They're eyeballing it. 1% changes the label, and they're eyeballing it. They don't have a protractor. They're eyeballing it. That's why one radiologist can look at it and say, that's a herniation. Another one look at it and say it's a bulge, and nobody's making stuff up. It's also why you're going to hear it is ridiculous to suggest one can come from trauma and the other can't. We're not talking about all the way around where it's just puffed out from weight. We're talking about something sticking out where it ought not be. And it's a matter of how much. And by the way, that kind of a bulge, it's just bigger. It's worse. There may have been more trauma. But to suggest trauma couldn't come from it, you're going to hear that is just medically and scientifically not just a little wrong, dead wrong. And now you know why.
And so when that expert comes up and testifies and has that supposedly aha moment in the defense's case, the jury already knows that there's real no distinction between a 24% versus a 26% bulge versus herniation.
Right. And look, every now and then you get one doesn't buy that definition, but it is the nomenclature definition that everyone's supposed to be following.
And I imagine, and I know you come in oftentimes and try cases that other folks worked up. I would assume then what you're looking for from the lawyers that work up the cases that you wind up co-counseling or co-trying it with is that they ask for the definition from the defense expert.
Good, very good point. Go ahead and get them to say what definition you're using for the distinction between the two. But once you hear it's eyeballing and it's a matter of degrees, everyone understands, how could you say that could be the difference between absolutely never and certainly could be? And then you throw in, and by the way, you can't diagnose usually whether it's traumatic or not. You can't, if there's swelling there, it's more likely came from trauma. Increased signal, they call it, a little more of the white stuff right there at the herniation. But even if there's not, that's not the way you really diagnose it fully and completely. Is you do a clinical correlation. You look at the film and you clinically correlate. Fancy word for me. And you got to look at the circumstances surrounding it. If there wasn't a problem before, it started with a crash, it's never gone away, and we look on the film and see that, you go, well, that's probably from the trauma. It could be all a big coincidence, but that kind of thing's painful. Could cause this exact pain. It's there, and the pain wasn't there before, and now it's there. Is it all just a big coincidence? Probably not.
And I've also heard, seen, I say heard, but I've seen you, when you cross-examine a radiologist, you distinguish between, facts versus conclusions. The MRI being, image being the fact, his opinion, his conclusion being an opinion. Can you talk a little bit about that?
You can tell we've tried cases, yeah. Exactly.
And why that's important.
That is really important because go back to the CSI aha gotcha moment that they try to turn it into. You've already built in this model of it's more conclusions from facts than disputes over facts themselves. And it applies to the jurors. They got that crash course on that topic during jury selection. You've kept it front and center in opening statement. You've continued to use them with your witnesses. Now their expert comes. On cross, you can remind them that the same principle applies to them. Say, sir, let's be clear. The fact in this case that can't be changed is that MRI. If the treating doctors look at it, they're looking at the same thing you are. If we hired someone, they're looking at the same thing. The spine doctor they hired to go with you as a radiologist, he looked at the same. The fact, it's fixed. It's one film. Everyone's looking at it. There are a bunch of slices, but it's the same exact film. That's a fact. Yes. And different people are giving different conclusions from that fact. But those conclusions they're saying are not the fixed fact. They are what we call an expert opinion, which is a conclusion that you say you reached. I don't even want to give them that you really believe it. Unless they're a real nice, likable person, you're just saying, got carried away by the competitive spirit and they really believe it, but they're wrong. Well, then you just say your opinion. Otherwise, I say that you say. You say, because that implies you're just making it up. You want to be clear what you communicate through your question. But when you apply that to the witness, then you can throw in. You've heard of confirmation bias, haven't you, sir? I had one just recently. No. I said, all that school and training and you wrote all those papers you were bragging on, you don't know what confirmation bias is? That's like a news flash to you. Well, let me explain it. That's where someone who's doing a study or doing some analysis has a conclusion that they have a bit of a bias for. They want it to be. They prefer it to be this, not that. And it impacts their evidence that supports the conclusion they want it to be, gets more weight put on it. Evidence that reaches an opposite conclusion than what they desire gets disregarded or downgraded. Starting to sound familiar. Yeah, I think I've heard of it. I said, oh, okay, so you have heard of it. Confirmation bias is a powerful tool too once you've adjusted their thinking that this is all just what someone says their conclusion is from looking at the evidence. They're not giving. You know what it does? There's no aha CSI moment. Now, they're just another paid witness spouting shit.
Yeah, and you know what I like, obviously seeing you address the confirmation bias as well as getting carried away with the competitive spirit. It's a way to tell the jury that this expert, even if it's tough to paint him as a flat-out liar or a flat-out terrible person, that they're still leading you astray. Without having to, they're wrong without having to go and say they're doing
path of least resistance.
Doing it, intentionally to come into this courtroom to try to mislead everybody.
It all depends on the expert. If it's some hired gun who's just aggressive as hell, and you don't need to play nice, you don't need to do that. I just had a guy up in New York, in Long Island. I normally they got to invite me to the fight. I don't start the fight because, you don't want to look heavy-handed. And I can come off heavy-handed. So I've taught myself, come in gentlemanly. I usually start, my name's Keith Mitnik. We've not met before. Good to meet you. I'm going to be asking you some questions. And I start nice. And the more they ramp up, I'll ramp with them. If they don't ramp, I stay down. This jackass came so hard before I even got up. He was ultra aggressive and selling total hogwash. And his last statement before they finished their direct was, it was some bus hit someone on a moped and said, I can tell you this, there is absolutely nothing this lady could have done different to avoid this crash. She did nothing wrong at all. Everything was appropriate. And I mean, we got an inside video shows her run the damn moped over in broad daylight. So I'm like, what the hell? And he was angry looking, looked like an old drill sergeant. And I thought, okay, this is the exception to the rule. So I didn't introduce myself. The first thing out of my mouth was, how much did that bus company pay you to give their driver a gold star for running my client over on his moped? Objection, argumentative, sustained. I said, how much money did this bus company pay you to say the driver of the bus that hit my client on the moped did nothing wrong? I just left out gold star. Objection, Your Honor, argumentative. Overruled. And that was the start. We stood toe to toe and duked it out. And the judge passed me later and said, that was fun. But anyhow, the point is that usually it isn't that way. It's fun when it is. My eyes sparkle a little. But most of the time, you want a path of least resistance.
Yeah, particularly with the more effective doctors.
Right. They're polished. They're nice. They're jurors laughing at their jokes. You don't want to call them a bald-faced liar. Unless sometimes they really may have convinced themselves it's true. I know a radiologist who I'm kind of friendly with who testifies for the defense. He really believes what he's saying, and he stays pretty neutral. He throws him a few bones, but he's not, the guy doesn't have a lion bone in his body. Why the hell would I cross him that way? Why would I tell the jury in closing something they're not buying? But so how do I explain they're wrong? People get carried away by the competitive spirit. It's natural. They're hired. They're picked. Number one, when you're picked for something, you're flattered. Then you get picked and paid. Now you're flattered and you really want to make your team happy within reason. Now you've met with your team and prepared for your team and you know what the team wants, what their end goal is, and what their game plan is. And you've been handpicked and hired to help them reach the goal. Some people will just call it like it is anyhow. But other people, just human nature, they're not bad people. They get carried away by the competitive spirit. They're on the team. They want the team to win. That's so much easier pill to swallow. Yeah. They're still wrong. You don't need to prove they're liars. They're not on trial. You just need to prove their conclusion's wrong. And it's just a conclusion.
And so
maybe
one of the one of the common experts we see in our cases are biomechanical experts. Yeah. Can you talk a little bit about your strategies for dealing with them?
Sure. They're new. I've always seen them. I haven't seen them at the frequency, and I'll tell you what, to me is new in the last 5 years is the biomechanical MDs. I don't think I ever saw one growing up. They're tough witnesses because they talk about complicated science. They have big credentials. Half of them are, working some space program or something. I mean, they're tough. So this is a perfect fertile ground to do some education. And you got to remember this. They don't have to be wrong on everything. In fact, they're going to be right on 95% of what comes out of their mouth. It's going to be Newton's physics, and there's no cross. They're right. But there's going to be a little bit woven in. There's not woven in. There's going to be a link. Good link, good link, good link, good link, good link, good link. But right here, there's a weak link. You got to find the weak link and expose it. Because once you break the link, the chain falls apart. It's only as good as its weakest link. We've all heard that. Don't waste your time crossing them on stuff they're right on. Find what they're wrong on. You can tell in the depot, you ask this and they can't wait to tell you. They want to tell you more and more. They're proud. They sit up. You ask the question they don't want you to ask and they don't want to answer. They change the subject. They duck. They shrink a little. Their voice goes down. They're a little less in your face. They realize, shit, I was hoping he didn't get to that. Go find the weak link. So what is the weak link with biomechanical engineers, especially the MDs? There are several of them. and you can teach. Here's a powerful opportunity to teach an opening with a biomechanical expert. There are a couple. Here's several things, but I'm going to end with the most fun one that kills them. Most of the studies they're relying on are with dead bodies or dummies. They're cadavers or dummies. Literally dummies. Well, guess what? I've never met a dummy that's got soft tissue and nerve endings, and it's kind of hard to hurt a dummy. And I've never heard a cadaver say ow. So from the beginning, you can teach the jury. All these studies, almost, because there are, to my knowledge, 2 studies they use that are live people. There may be a few more. Almost all their studies are dead cadavers and dummies. Dead people and dummies. They don't react like human beings. Here's another thing, folks. The evidence is going to show this is what you're going to hear. That the very small number of studies they rely on that involve live people, they had them all sign release forms, so if they got hurt, they wouldn't sue. And he's saying it wouldn't hurt a flea. Why do they need a release form? So those are some little pieces of it. Now here is getting into the big part of it, though. 2 pieces. One of them is, it all comes down to, they can't help themselves. They got to convert it into activities of daily living. ADLs, activity of daily living. And there are all these studies that will say, what are the forces for an activity of daily living? And they will run all these other numbers, usually by looking at a picture, back to eyeballing. They will take a crash photo, compare it in a big database on a computer of other crash photos in which the government studied it, and they know what the forces involved were. So they look, oh, that looks kind of like this one. And the forces over here were 3G, so this must be 3G. Well, now, that's pretty iffy. Science isn't supposed to be iffy. Math isn't 1 + 1 equals kind of maybe 2. Is 2. So the iffier it is, the more assumptions there are instead of raw, pure data, the less reliable the outcome is. Bad in, bad out. And let's start with the beginning of this whole thing is, they're coming up with forces by eyeballing pictures and then going over here and looking at a similar picture in a different car, in a different crash at a different time, and say, that's as close as we can get, and therefore. And then they put a little range to try and make up for the uncertainty. The minute you start seeing ranges, you're seeing no science. You're seeing guessing, assumptions. But now I just educated, and they just came off their high horse now. This is the killer education. They then take whatever the G-forces associated from their eyeballing onto the program and convert it into activities of daily living, because there's a long list of what the G-forces are on those. And it comes out to something like, I got one where someone was going into a convenience store, leaving, and she got stuck at the door because some guy has got a big roller with cases of beer stacked up, way up. And he's coming through the door, and she's waiting for him to come through because there's no room, standing off the side. Well, he hits that little riser. Here comes 1 case of beer. Boom, hits her right here on the shoulder by the neck. Here comes another one. Boom, hits her twice. Oh. And she flies out of the picture. It's on video. You know what they came up with the Delta V? I mean, not the Delta V, with the activity of daily living equivalency. Picking up a jug of milk, gallon jug of milk. Or sitting in a chair or laying down in a bed. So you want to teach a jury, you go through all that and say, so here's all you need to know. The guy they had and pay, has got credentials. Ooh, can he talk? He is a good talker. But let me tell you what he's going to say. At the end, it's all to say that and play the video. People are going, oh my God, is the same as going to your, taking out the refrigerator, grabbing a jug of milk, and going over here. That's the same. Or this, pull my chair up. Or laying on a bed. Except not a hard thing like this with a mattress. That's what he's trying to convince you of. You get to decide whether you're going to buy that conclusion. Because at the end of the day, he's going to talk and talk and impress, and that's the end. To say it wouldn't hurt a flea.
And that's all an opening.
Opening.
You want to get way ahead of that.
Why would I let that big dog get up and start trotting around? I'm putting that dog down before he ever gets up.
We're pretty far along in this episode, but if you want to talk briefly about kind of the sensible sequence when it comes to the doctors and what your thoughts are on that.
Sure. Let's finish with that. Folks that have listened to me will have heard me done this before. But I do want to bring it back up just for a moment, just because it fits another example of education. It fits in what we're doing, and I want so bad for people to take, when we're done with all these episodes, I understand this powerful packaging process you're talking about. And we're about to leave the education one. And I don't know a much better one as an example. So I'm glad you brought, I was going to skip it. I'm glad you brought it up. You got their spine expert up. You're going to cross him. You can do it in opening. Get out in front of it. You can do it in closing. It fits all over the place. Probably sooner rather than later is better. But he's, at the end of the day, his story is sprain, strain, healed, degeneration. Not you're making your pain up, although they'll hint it. But they're going to say, officially, sprain, strain, so you got hurt, and then you healed, and now any pain you still got going on, natural aging, degeneration. The problem with that you can teach the jury, is it doesn't make a lick of sense when you use what I call a sensible sequence of events. Let's use the clean example. Didn't have the problem before. It works just as well. Had the problem, had a neck problem, lasted for a year or two, haven't had a problem in 10 years, haven't had a treatment, haven't had anything. Let's use, didn't have any, look, never get up and say, never had a pain in their neck before. No one's going to believe it. And why would you have to say that? Never had any kind of neck problem, ongoing neck problems. I always say, everyone's woke up, slept wrong sometime to time, but no one said, she's never had ongoing neck problem, never had surgery, never had recommendation for surgery, never had an injection, never had an MRI on it, never been to a chiropractor, never had physical therapy before. Not a single doctor she went and complained about it to. 50 years old, got in this crash, had neck pain right away, started seeing doctors. The treatment went from seeing a chiropractor, hoping it was all going to get better and go away. Didn't go away. When it didn't go away, decided I better go to the next level of care. Went to see a spine surgeon. They got an MRI. Went, oh my gosh, bad news. This isn't a sprain strain. They all start looking alike, but when it doesn't heal, we need to look and see if it's more. It is more. You got a herniation. Now here are your choices. Went to the conservative care. That didn't work. Now surgery. Now my clients had surgery. Surgery helped with the radiating pain, because that's what it works on, those big cords, but it doesn't help with the regional pain, the local pain. That's still, they're still living with neck pain. Didn't have it before. And what their doctor is going to tell you is that, yes, didn't have it before. Yes, it started at the time of the crash. Yes, it never went away. Yes, it's in the identical place it was from the crash. But now, magically, 6 weeks out, it stopped hurting, and at the exact place and the exact character of pain, like a lightning bolt out of the sky, the aging process started hurting right there. And it wasn't hurting the day before the crash, the day before, the 10 years before. You got to decide. After they admit the crash caused an injury to her neck at the same place that's causing her the exact pain today, is it all just a big coincidence?
I know you put a lot of emphasis in your openings on educating the jury on that issue, because in your you use PowerPoint slides, you show all the treatment afterwards, none before. I know that winds up being a major point of emphasis for you to educate the jury, and I've seen how effective it is, and you can compare that to if you don't get ahead of it. It's a different story.
Imagine opening without it, and they get up and say, we're going to bring you so-and-so. They trained at Harvard, they're this, they've operated on 10,000 spines, and he's going to tell you that, yes, there was a sprain strain, but there's absolutely no anatomical change with all modern science and everything we have and all the MRIs and everything done, all the tests run, everything. There's zero evidence that there was any change to her spine that would cause a permanent injury, just a soft tissue sprain strain. Now, you are going to see on the spine abnormalities, but not everyone agrees, including the plaintiff's doctors. Those abnormalities were there for years before they crashed. They weren't caused by it. There's this drying of the disc. There's the shortening of the disc height. There are these spurs. So she's got all these things that can cause pain in her spine. It's a bit of a mess in that very area. And there's absolutely no indication whatsoever that anything changed in the spine that would explain this. It's all just, it was a sprain strain. Does she have some ongoing neck pain? Well, she's 50 and she's got all these abnormalities of aging. Of course she does. And the juror's going, why are you wasting my time on this frivolous case? You do the sensible sequence and let them get up and do it. It doesn't work. It does two things. It is a powerful education to prove their conclusions wrong. It's also a powerful education that proves your conclusions right.
Well, look, this was a very, helpful discussion and practical discussion concerning dealing with one of the real hurdles, real challenges we face in trying these sorts of cases is the defense experts who tend to be, some of them are very good. And, I know I've seen in practice how important it is and what a priority you put on educating the jury about the defense experts before they ever testify. And I'm glad we got to talk about it. And this is our, now that we've, and I know that education in general is a big part of, your trial strategy. And I'm glad we spent 2 episodes on it because I know how, in practice, how important it is for you. So our next episode, we're going to be covering your next tool in the toolbox, context, and I look forward to that. And in the meantime, thanks a lot, Keith, for your time. Well, that was a great episode as we really focused on how we can expose the flaw in the defense experts' testimony, which is always one of the challenges we have, and got to hear a number of strategies and real examples that Keith has used in the courtroom. We're looking forward to our next episode, which is going to cover the next tool in Keith's toolbox, which is providing context and using that to expose the flaw in the defense's case.
We have now nailed down the time and the place for the next Art of Outsmarting event. We're going to be in Orlando. We're going to be at a fantastic venue called the Dr. Phillips Center for Performing Arts. It's a new facility. We did it there last year. It was off the charts good. I promise new materials, and I promise a brand new format I've never done before that I'm so excited about. I can't wait for May to come. See y'all there.